And I mean specifically the 1998 tobacco settlement, and I know Ted Cruz is well aware of what I'm talking about as well. But 46 states entered into a $200 billion deal, all done by state attorneys general and major tobacco companies without the consent of Congress. In fact, Congress had an opportunity to approve the settlement agreement and didn't. And it was a $200 billion hidden tax, a massive regulatory scheme. Now every single state attorney general office in 46 states has a deputy attorney general just to enforce the tobacco settlement. So I just want to sound a cautionary note here that that compacts can be used against us, and we have to craft this thing carefully so that we're not turning loose the other side as well. And CEI has a case before the U.S. Supreme Court actually specifically on the compact clause challenging the tobacco settlement. So we're hoping to get the Supreme Court to rule on what the compact clause does and does not mean.
Well, thank you very much, and thank you for that cautionary note. But the way that we look at it is turning the tables. I mean, when we have some of our groundwork has been done by radical left-wing environmentalists and people involved in the tobacco settlements, and we take that and say, oh, that is a brilliant idea, isn't it? We can think of other ways to use this idea too, and you might not like some of them as much as, but I think that's where.
I'm a placeholder.
Thank you very much.
I'm a placeholder here. If you have questions, if you'd line up behind me and ask them from the microphone so everyone can hear. Thank you.
Thank you very much, Arlene.
I just have a question specifically about the health insurance compact. This is a kind of a technical issue, but we have an insurance compact extant that is in effect for life and annuity insurers, and it has technical committees, it has an audit committee, it has all that. 36 states are already members. Would it not make sense to read health insurance into the already existing insurance compact that is in effect for life and annuity insurers? Isn't that easier than building up a whole thing from scratch?
Do you want to take that, or? Yeah. I mean, I think the answer is that what we have throughout the country and 200 different interstate compacts is a library of precedents that we can use. The annuities and life insurance compact is good by way of examples, but the problem with translating it into health care generally is that in the area of health care, the federal government has been so much more intrusive. It's been so intrusive that the states effectively can't, the federal government through the health care regulations and through federal funds with conditions attached is basically federalizing every area of domestic policy. Gradually, and it's done it in healthcare to a point where, and you know this, Bob Moffat as well as anybody, when you try to fix anything, if you try to say, well, we're going to make this patient portable, well, you can't do it because there's some federal tax law that makes it impossible. We're going to expand the use of community health clinics. Well, you can't do that because there's a million different mandates from the federal government. And the point is, the first step is to create, to devise a federal, an interstate compact that is a page long, 2 pages long, that contains a series of principles that everybody can agree on, one of which is the federal, Congress hereby consents, by consenting to this compact, Congress consents to allow the member states to regulate health care themselves. And that's and the precedent for that lies, we're drawing as an example in the Washington Area Metropolitan Transit Authority, which has a little provision that says, we are going to, federal liability laws with respect to employer, accidental death liability is suspended with respect to the compact. Well, if a compact can suspend federal law as to something minor, it can suspend it as to something major, and that's the idea that we have.
Yeah, Michael Sonera from the John Locke Foundation in North Carolina. I'm the local government guy at John Locke. And I think we also have to remember that the federal government doesn't just go to the states, it goes down to local government. And I'll give you one example and then ask for what the state legislators can do to preempt this. We have the Department of Energy is going directly to Appalachian State University and with money, and the university is going to the counties and cities saying, we will help you write wind ordinances for your county. Please come to us and we will help you write those. This is federal money going down directly to the counties and cities. What can state legislators do to preempt that?
Do you want
Can they pass a law that says any federal money that comes into the state must be approved by a committee or commission or agency set up by the state government before it can be accepted?
You know, it would depend on the terms of the federal authorizing statute. As a matter of state law, it would seem clear that you could have a state legislature, depending on what the state constitutional situation is and the home rule situation of states, but in states where the legislature has plenary authority, it would seem clear as a matter of state law you could pass a bill that says local universities, municipalities cannot accept federal funds without the explicit permission of the legislature. Now, if there's federal legislation that explicitly conflicts with that, the courts will give that preemptive effect. But absent a clear conflict, the courts will apply both. And if it is simply spending clause expenditures from federal government, if the feds aren't directly forcing them to take it, I wouldn't see any legal impediments to the states saying you can't accept without our permission.
I would recommend that. In North Carolina, we don't have home rule, so it might be easier there.
But actually, so in the agenda for state action that we've developed, one of the things that we address is the problem of federal funds with conditions and mandates attached. And there's a simple way we think to deal with that, which is to start passing reciprocal legislation in each of the states that says it's illegal to accept federal funds into the state budgets with mandates attached, except X, Y, and Z exceptions, and have the effective date of this legislation shall be when 26 states have passed similar legislation or 38 states have passed it, because then you change the political dynamic. Now you have appropriators in Congress that are saying, well, now you've got 3/4 of the states, it's illegal for them to accept these funds, and we're from those states, so we can't use this device to go the enumerated powers of the federal government have already blown way past their limits, and now the federal government's come up with something to regulate even outside what it thinks are its enumerated powers, and is using the federal funds at local and state level to federalize all areas of government. And it's the new danger. It's coming. I mean, if you look at your budgets, take a look at your budgets, and ever since the stimulus, at how much federal, at how the presence of federal funds, the proportion of federal funds, how dramatically it's exploded over the past 5 years. Well, if that trend keeps going, the state budget is going to become federal.
Let me take a moment actually to expand on that point Mario made, because it's a different point from the Interstate Compact, but it is another idea that's in the agenda for state action that I think has real potency. I mean, one of the great things about the Tea Parties and what's happening right now is you have a lot of smart, energized warriors for liberty that are thinking creatively about every mechanism to chain the beast. One of the issues every one of you deals with is federal funds and the strings that come attached to it. And I know in Texas there are periodic discussions about the legislature just saying no and turning away the federal funds. Now the problem, for any of y'all who have studied economics, the problem is a game theory problem, and it's the prisoner's dilemma, which is any one state, if you're the first mover, you're at a disadvantage because your citizens keep paying the taxes, so you can turn down the money and just pay for every other state to get the money. And that's a difficult vote to make because whoever moves first is at a disadvantage. The piece that is really diabolical that Mario just said is turning down the federal strings, but doing it only as reciprocal legislation, which means each legislature passing a bill that says, this state will accept no federal funds with strings attached. This bill will become effective when the same bill is passed by 24 other states.